Losing your job can be a difficult and upsetting experience. Trying to work out what your legal options are might be the last thing you feel like doing, but it is important to know what your rights are because there are strict time limits for when you must file a claim. Sometimes these can be as short as 21 days from the date you were dismissed, so it's worth knowing what your options are early on, even if you later decide not to take any legal action. There are a few different types of claims that you might be able to make. We talk about the two most common types of claims. The first type of claim is called an unfair dismissal claim, and as the name suggests, it applies to a variety of situations where a dismissal is considered unfair. Both national and state system employees can make unfair dismissal claims, although the processes are a bit different. The second type of claim applies to a particular type of circumstance, and that is where you were dismissed for a reason which is not allowed by law. For state system employees, this second type of claim is called unlawful termination. For national system employees, it is called a general protections claim. A general protections claim is sometimes also referred to as an adverse action claim. You might think of it this way. Unfair dismissal claims are made when your employer didn't have a good reason for dismissing you or didn't follow a fair process when dismissing you. Unlawful termination and general protections claims are made when the reason for your dismissal is so unacceptable that the dismissal is considered more than just unfair. There is a list of these unacceptable reasons, and we call them prohibited reasons. One important thing to remember is that you must choose between these claims. You can't file more than one of these claims at the same time. But before we look at each of these types of claims, there is one thing we need to discuss. It's called constructive dismissal.